In an appeal filed by the editor of a Kannada newspaper, seeking relief against the magistrate's orders, the Karnataka High Court upheld the decision. The appellant was accused of committing the offence under Section 23 of the POCSO Act by publishing the identity of a 16-year-old girl who was subjected to sexual crime. A two-member bench of the Supreme Court, comprising Justice Indira Banerjee and Justice J.K. Maheshwari, was considering the appeal filed by the editor, observed that the short question of law involved in this appeal is whether Section 155(2) of the CRPC applies to the investigation of an offence under Section 23 of POCSO. The bench came out with a split verdict. Namaste. My name is Deepthi. Justice J.K. Maheshwari opined that the magistrate's permission was required as per Section 155(2) of CRPC since the offence recorded under Section 23 of POCSO is not cognizable. Justice Indira Banerjee held otherwise. Now the matter has been referred to CJI to constitute an appropriate bench to resolve the issue. A senior counsel appearing for appellant argued the case as 1. The maximum imprisonment under Section 23 of POCSO is 1 year. As per Para 2 of Schedule 1 of CRPC, offences with imprisonment of fewer than 3 years are classified as non-cognizable offences. So, the offence under Section 23 of POCSO is non-cognizable. 2. Section 19 of POCSO deals with the process of investigation of POCSO offences, which does not include Section 23. 3. Section 23 of POCSO does not exclude the provisions of CRPC, therefore Section 155(2) of CRPC is applicable. It is a mandatory provision. Justice Indira Banerjee disagrees. In this context, Justice Indira Banerjee disagreed with the arguments and said, 1. Section 19 of the POCSO Act does not exclude offences under Sec 23. The expression, offence in Section 19 of POCSO would include all offences under POCSO including an offence under Section 23 of POCSO, of publication of a news report disclosing the identity of a child victim of sexual assault. 2. As per Section 19(5), the police unit shall make immediate arrangements for the care and protection of the victim child if it is of the opinion that the child is in need of care and protection. Action under subsection 5 of Section 19 of POCSO has to be taken with utmost expedition. Such action obviously involves investigation into whether an offence has been committed and whether the child requires special care. 3. Section 19(6) requires the police to report the matter to the Child Welfare Committee and a special court without delay. 4. If the legislature had intended that Section 155(2) CRPC should apply to Section 23, it would have specifically provided so. In this regard, it was noted that Sections 31 and 33(9) of the POCSO specifically incorporate CRPC provisions in Sections 4(1) and 4(2). 5. Justice Banerjee also spoke about the need to protect the dignity and privacy of the child. Every child has the inalienable human right to live with dignity, grow up and develop in an atmosphere conducive to mental and physical health, be treated with equality and not be discriminated against. The inalienable rights of a child include the right to protection of privacy. The Constitution of India guarantees the aforesaid inalienable and basic rights to all, including children. The right to live with dignity, the right to personal liberty, the right to privacy, the right to equality and/or the right against discrimination, the right against exploitation, are fundamental rights guaranteed by Part 3 of the Constitution of India. Justice Maheshwari's analysis. 1. Section 19 does not state that all POCSO offences are cognizable. 2. Section 19 also does not provide how and in what manner the investigation on reporting of the offences ought to be made. 3. Thus, In absence of having any procedure for investigation under the POCSO Act, either for cognizable or non-cognizable offences, as mandated by subsection 2 of Section 4 of CRPC, the procedure prescribed in CRPC ought to be followed in the matter of investigation inquiring into and trial. 4. Section 5 of CRPC is a saving clause by which the procedure prescribed in the special enactment will prevail otherwise in absence of the provision, and the procedure specified in CRPC may be applicable. Justice Maheshwari observed that, on the basis of precedents, the application of Section 155 2 CRPC to Section 23 of POCSO is a mandatory provision. The word magistrate in Section 155 2 CRPC has to be understood as special court in the context of POCSO. Referred to CJI. To judges being of the different opinions and a split decision, it was stated in the order. Since the bench has not been able to agree, the registry is directed to forthwith place the matter before Honorable the Chief Justice of India for assignment before an appropriate bench. To know more, join us on YouTube, Instagram, Facebook, LinkedIn. Find links in description.